Secrets. They cause tension, they cause paranoia, they cause distrust. This is exactly what secrecy in the court system does. When court proceedings are conducted in secret, or when documents are kept under wraps, we have moments in history, like the Spanish Inquisition or the English Court of Star Chamber, where abuses went unchecked. The Spanish Inquisition was shrouded in secrecy. All documents were kept secret. If a witness made public their testimony, they faced fines or worse, excommunication. The English Star Chamber was a place of great abuse. Most of the time, the accused were subject to torture without even knowing why they were being held. Secrecy was the main characteristic of this court. The secrecy perpetuated by the Spanish Inquisition and the English Star Courts gave way to a distrust of the judicial system. This resulted in a drive toward openness within the courts. The principle that justice cannot survive behind walls of silence has long been reflected in the Anglo-American distrust for secret trials. Jeremy Bentham said, "Suppose the proceedings to be completely secret, and the court, on the occasion, to consist of no more than a single judge. That judge will be at once indolent and arbitrary. How corrupt soever his inclination may be, it will find no check, at any rate no tolerably efficient check, to oppose it. Without publicity, all other checks are insufficient in comparison of publicity. All other checks are of small account. Recordation, appeal, whatever other institutions might present themselves in the character of checks, would be found to operate rather as cloaks than checks, as cloaks in reality, as checks only in appearance." The international distrust of secrecy in courts highlighted several purposes for the presumption of openness that rose out of the abuses of the Spanish Inquisition and the English Star Courts. Open court proceedings create an atmosphere of fairness in a therapeutic setting for the public to express their concerns and emotions regarding certain issues. Public access to the judicial system allows the public to act as a check on the system. Public check on the judicial system serves several purposes. First, it creates an environment of truthfulness which encourages respect for our legal system. Second, it upholds the worth of the fact-finding process. Third, it prevents the court from using judicial authority as a weapon. Fourth, it allows the public to remain informed and learn what is right and wrong. English courts saw the benefit of an open court system and incorporated openness into their common law. The presumption of openness became a characteristic of almost all court proceedings and documents. The United States adopted this presumption of openness into their own legal system. The framers of the Bill of Rights and the subsequent amendments integrated this principle of openness heavily into the laws governing the American legal system. The First Amendment prohibits Congress from making any law limiting a person's or the press's freedom of speech. This amendment implies that the public and the press have access to the judicial system. The Sixth Amendment guarantees the accused the right to a speedy and public trial in front of a jury of his or her peers in a criminal trial. The word public implies not only the right of access but the necessity for the public to act as a check on the judicial system to ensure fairness to the defendant. At the same time, this right of access is second only to the fairness of the accused trial. If the accused may be denied access to a fair trial, then the public may not have access to certain proceedings or documents, but more on that later. The 14th Amendment, or the Due Process Clause, means that no person can be deprived of their liberties or rights. This means that the accused cannot have their right to a fair trial taken away. The legal system is heavily influenced by this presumption of openness, but the question remains, are all documents under all circumstances subject to this presumption? The answer to that question is no. Sealing is the process by which a person, corporation, or government may move to keep certain documents or proceedings out of the public's reach. The trial court has the authority to decide whether documents are sealed or not. But first, the party seeking to seal must show good cause or explain their reasoning as to why something should be sealed. The party must present a specific and compelling argument to override the presumption of openness incorporated into both the common law and the First Amendment. The common law and the First Amendment both include the presumption of openness with regards to court documents. This is a most valuable and important right, and it takes a lot to overcome the presumption and seal a document. Under the common law, the trial court must balance the interest of the party moving to seal against the public interest in that particular document. Oftentimes, the court will look to factors such as fairness to the accused, the ability of witnesses to tailor testimony or destroy evidence, potential challenges to ongoing investigation, and the availability of comparable and reasonable alternatives. These reasonable alternatives may include a change of venue or postponement of trial or redaction, which is the blacking out or elimination of certain prejudicial material from the document. The common law approach to sealing documents provides a relatively low bar to overcome the presumption of openness. Conversely, the First Amendment approach requires a higher standard of scrutiny or analysis. When considering whether to seal a court document or not, the trial court must look at three things. 1. Is sealing necessary to serve a compelling governmental interest? 2. Is sealing carefully molded to serve that interest? And 3. Are there any less restrictive alternatives that could serve that interest without sealing, such as a redaction? If the court finds that sealing is necessary to serve a compelling governmental interest, the remedy is carefully molded to serve that interest, and there are no reasonable alternatives, then the document will be sealed. Under the First Amendment, the public is given the opportunity to gain access to a sealed document by fulfilling the two prongs of the experience and logic test. The experience prong requires a finding the specific document has historically been open to the public. The logic prong requires a finding the public plays a positive role. For example, the public could claim they need access to a document to act as a check on the courts or to ensure accurate fact-finding. There is no overarching rule that requires the common law or the First Amendment to be applied to all documents in all places. Different jurisdictions will apply different approaches to different types of documents. For example, Massachusetts applies the common law to search warrants and briefs and memos, while they apply the First Amendment approach to court dockets. Other jurisdictions may apply different standards to those same documents. Speaking of Massachusetts, it is one of the worst states when it comes to access to information or court documents. According to the Boston Globe, it is ranked 40th worst state when it comes to public access to information. It receives an F from the American Civil Liberties Union. Massachusetts has a highly inefficient system that makes gaining access to court documents extremely difficult. This system is composed of high costs and delay. Why should you care? You should care because it is a responsibility to act as a check on the legal system we expect to uphold and interpret our rights. You should care because public access prevents the court from being used as a weapon of persecution. You should care because it is your right to know. Thank you for watching. Please take a moment to fill out the attached survey.